Welcome to ABC Paralegal. My name's Claire and this channel aims to help people known as litigants in person and offer practical guidance on navigating family court in England and Wales. I will explain court procedures, common mistakes, what to expect during hearings under the Children Act 1989 and the Family Procedure Rules 2010. I will also cover topics in divorce and financial separation. If you want clear, practical insights into how family court works, consider subscribing. The first thing you should understand is what type of hearing you're attending. Not all hearings in family court are the same. Many hearings in child arrangements are known as First Hearing Dispute Resolution Appointment, often referred to as a FEDRA. At this stage of the court process, they're not usually making a final decision. Instead, the judge is looking to identify key issues in the case, review safeguarding information, and see what, if any, an agreement can be reached between the parties. And understanding the purpose of the hearing will help you focus on what the court is trying to achieve. Most disputes involving children are decided under the Children Act 1989. Under this Act, the court's paramount consideration is the welfare of the child. This means the judge is not deciding which parent is right or wrong in a personal dispute. The court is focusing on one question: what arrangement best promotes this child's welfare? And that is why it's important that everything you present to the court focuses on the child rather than personal grievances between parents. Before attending the hearing, you should carefully read every document you have received from the court. This may include the application form, known as the C100, safeguarding letters from CAFCAS, statements from the other party, and court directions. The court directions are particularly important. These instructions will be issued under the Family Procedure Rules, which may require you to provide documents, prepare a witness statement, or submit evidence by a specific deadline. Missing these deadlines can cause damage to your case. Family courts rely heavily on clear, organised evidence. If you want the judge to understand your position, you must be able to refer to documents quickly during the hearing. Examples of that evidence might include school correspondence, medical records, emails or text messages, reports from contact centres. Try to organise your documents in chronological order. If possible, create a simple list or an index so that you can quickly locate documents when the judge asks about them. And the judge will appreciate litigants who are organised. And an added point, if courts rely a lot on bundles, so it could benefit to apply Family Procedure Rules Practice Direction 27A, and in that practice direction it explains how to formulate a bundle. One common mistake litigants in person make is trying to explain every issue with extensive detail. Family court hearings are often short, and the judge may only allow a limited time for both parties to speak. So instead of trying to explain things that, although are important to you, they may actually seem irrelevant as a result of this process, try to create a bullet point list, a script, 3 or 4 key points. It can be more. That's just an example of what you want the court to understand. So, for example, the situation, what has led you to here, the child's current living arrangements, any concerns affecting the child's welfare, the outcome that you're asking the court to consider. Writing these down beforehand can help you stay focused to your position during that hearing. How you behave in court matters, how you dress in court matters. Judges expect litigants in person to remain calm and respectful throughout proceedings. Some simple points to remember include: address the judge as Judge, Sir or Ma'am, avoid interrupting the judge or other speakers, remain composed even if you know falsities are being raised or difficult allegations are being put forward. Court hearings and almost mentally prepare yourself on this one. Court hearings can become emotional, but remaining respectful throughout helps ensure your case is taken seriously. And that's not to say you can counteract or address these allegations, but it's very much in the way that you do it. If you are attending in court without a solicitor or barrister, you may bring someone with you to assist you during the hearing. This person is known as a Mackenzie friend, and their role is recognised under Practice Guidance, Mackenzie Friend, brackets, Civil and Family Court. A Mackenzie friend can take notes, help organise documents, quietly advise you during the hearing. However, they usually cannot speak to the judge directly for you unless the court gives permission. And I make a real point to people that if a Mackenzie friend approaches you and kind of states that, oh yeah, I can get rights of audience, that's not correct. So I'd be very wary in working with that person. On the day of the hearing, there are a few practical steps that you can take to make the experience much easier. Try to arrive at least 30 minutes early. Bring all your documents with you, including any notes that you've prepared. And court buildings can be busy and confusing, so arriving early it just allows you that time to find the correct courtroom and organise your papers. One of the most important things to remember about family court is that it's not simply about telling your story. The court must consider the evidence, they must follow procedure rules, and ultimately make decisions based on the child's welfare. By preparing properly, organising your documents, focusing on the issues at hand, you give yourself a better opportunity to present your case clearly. In the next video in this series, I'm going to be looking at 5 common mistakes litigants in person make during family court and how to avoid them. So like and subscribe for more practical guidance.